SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. Land dispossession is a term we became familiar with in the apartheid era when non-white communities were forcibly removed from certain areas to government-specified locations. The new South African government has taken a bold step in attempting to redress some of the injustices of the past.
A great deal of land dispossession happened right throughout the 20th century, so it wasn't a single point in time. People were removed from rural areas in the course of implementing the 1913 Natives Land Act, but later there were further acts. There were regulations that prohibited sharecropping and labour tenancy on white-owned farms, and of course in the urban areas in 1950 there was the Group Areas Act. So land dispossession happened not just once, but in some people's lives they were dispossessed many times.
Land law and property rights in this country were built essentially on a racist foundation, and the general idea of land reform would be to address not only those underlying power relations, but the consequences of them as well.
Zililela ntoni zinyanya umhlaba wezinyanya zami zililela ntoni zinyanya umhlaba wezinyanya zami zililela ntoni zinyanya umhlaba wezinyanya zami Kuyalunga sido sikabawo Kuyalunga sido sikaphalo madoda ndithi masibhinqeleni phezulu ngoba kaloku ngoku ingathi kuzawulunga kwaye masilumke ngoba ingathi khona inkanyambezayo namhlanje xa sime kule ndawo ndiba novuyo kum ngaphakathi ngoba ndibona sihleli ngomhlobo phezu kwabangcwaba oba umkhulu kwaye ndikhumbula mhla siyasikhutshwa ngapha kulizwe lakowethu sikhutshwa ngenkani sobekwa kule ndawo singavumi sinomsindo sisilwa kodwa ke zange silwe kwaye sikhathale kakhulu ngoba kaloku ngaphakathi sasinethemba kuba siyazi into yoba ngaba sawufika apha sicebisane sibonisane sichebane induma kutsho mna unzothi unyelenza umaphanga ungcuku ungcala umphakomo
tyhini naleli bhutyhini hayibo hayibo.
In South Africa, we have this history of forced displacement of black people that was motivated by a few factors. Firstly, the emerging economies of the mining industry, of urban industry, and of white commercial farming all competed for access to black labour. So displacing black people freed up cheap labour to support these emerging industries. Another reason was, of course, to make available white commercial farmland and to support the emergence of a commercial farming sector. And a third reason was very much an ideological reason in the era of grand apartheid, which was to create black self-governing territories, the Bantustans, and to separate white from black.
Post-94, it became clear that some people had to be restored to their former homes and their land, and the government had to come up with a method and a system of ensuring that that happens in an orderly way.
In 1994, the Land Claims Commission was established as a body to adjudicate land claims on the basis of mediation. Its purpose was to verify and validate the extent of the land claimed and identify rightful beneficiaries. Where the commission could not settle a claim, the matter would be referred to the Land Claims Court.
What happens when one submits a land claim is that there's a process of, firstly, investigation of the land claim by the Land Claims Commission. It's then gazetted to various parties, and the Land Claims Commission and the claimants can reach an out-of-court settlement, often through mediation or negotiation. If that's not possible, there's two circumstances where the case could go to the Land Claims Court. The first is if the Commission actually refers it and says, we cannot reach agreement in this particular case, the matter must now go to the Land Claims Court. But Section 38 of the Restitution Act allows you to approach the court directly and to say, I lost the right in land, I qualify in terms of the Act, and the Land Claims Court can deal with the matter directly.
The government called for all persons who had been displaced through forced removals to lay a claim so that the claim can be considered, adjudicated upon, and disposed of.
Importantly, the Act says that in order to qualify, there should not have been just or equitable compensation received for that disposition. And the Act also says that the claim, the land claim, should have been lodged by the 31st of December 1998. That's a very important requirement.
After hearing about the Maduna community's struggle, a team of lawyers offered their services free of charge, in legal terms also known as pro bono.
We know that the cost of relocation will be a huge deterrent. We're talking 50, 60 million.
Probably more.
Tata, we have to be prepared for the relocation to be rejected.
Guys, I understand this is going to cost a lot of money, but we are talking about my people's rightful land here. Bodies of my ancestors are still lying there in that earth. Surely the court will understand this.
I hate to say this, Tata, but the opposition will say that if you are relocated, your people will get back much more than they left behind.
And so we should.
All we're saying is that if you don't get the land back, there are other options here. Maybe we could get you unlimited access to the gravesite.
We could ask for state funds to build a clinic, school, roads for New Timori. We could even fix the water situation with that money. You see, we need to go to court with a plan B. We need to look at all the possibilities. Or we could get left in the dark.
I think you should seriously consider staying in New Timori. But only if facilities are built and resources are improved.
Government has the responsibility to oversee this process of restoring land to people who were dispossessed. Government is required to make resources available, and so it must be feasible for government, for the community.
There's a number of organizations that assisted people during the restitution process to complete claims. Various non-governmental organizations, especially in the land rights arena, were extensively involved in that. South Africa is lucky to have quite a few public interest legal organizations like the Legal Resources Center, Lawyers for Human Rights, and various other NGOs that could assist in that process.
Legal practitioners, advocates and attorneys offer pro bono services. For advocates, the pro bono services are provided not directly by engaging the advocate, but by engaging the Bar Council, which is the overseeing body of the advocates, who then will appoint an advocate to perform pro bono services.
Coming up, we see the Maduna people's desperate fight for their land.
Hungry people cannot work. Hungry people cannot survive.
The Land Claims Court was set up in 1996 to deal with disputes arising in the context of the post-apartheid land reform program, which included restitution, redistribution, and tenure reform. The court deals with claims brought in terms of the Restitution of Land Rights Act, the Land Reform Act, and the Extension of Security of Tenure Act.
Historically, the land reform policy of the Department of Land Affairs, now the Department of Rural Development and Land Reform, has been on three major programs. The first one has been restitution of land rights. That is cases where people have lost land through apartheid laws, etc. The second one has been around issues of tenure reform. That is people that are living on land and that are living in in insecure circumstances because of various reasons. And the third one would be the land redistribution process.
It's very well thought out legislation, the Restitution Act, and the other acts. We also work with acts relating to eviction of farm workers particularly. So all of that provides guidelines for the judges.
In February 2011, a court battle began where the Maduna people hoped to claim back the ancestral land that they believed was rightfully theirs.
Mr. Maqetuka, please tell the court what life was like in Old Somori before the forced removals.
Life was good. Our children in the school. And the sick at the clinic. We had no problem accessing water. We grew our own crops and were able to take care of our livestock. Our people were strong. They were proud.
What's life like in Utsumari?
We were cut off from the world. We don't have necessary facilities to survive. We put all our money together maintaining this land, but nothing is improving.
Why not?
The main problem is water. You see, we know where the water source is, but we can't get to it.
And what has this meant for the Maduna community?
No water means no crops, means no animals, which means we are forced to go hungry. Hungry people cannot work. Hungry people cannot survive.
I have no further questions, my lady.
Normally the evidence in a particular land claim, and I'm talking now in the context of claims that are put before a court, would be the evidence of the particular claimants themselves. So they would, for example, give oral evidence or give testimony to the land claims court explaining how it was that they actually lost those rights in land. Interestingly, in many of these cases that we've come across, the claimants are often in possession of the actual documentary evidence of their removal. The apartheid state, very similar to the Third Reich, kept very detailed records of its administrative procedures. So often people would have the notice of expropriation and so forth that they would have kept for 40, 50 years.
But can the community maintain what is now a thriving commercial farm?
Mr. Maqetuka, I understand that dozens of your people are employed by the respondent, Mr. Lobsher. Is that correct?
Correct.
You spoke earlier about work being difficult for the Maduna people. If Mr. Lobsher here is the main employer of your people, surely your community's economy would be affected if Mr. Lobsher moved his farm elsewhere?
We can employ ourselves.
Now that is a slightly naive idea, don't you think, Mr. Maqetuka?
Not at all.
Is there an engineer among the Maduna people?
No.
Anyone with experience in running a commercial farm?
No.
Dairy farming?
No.
So how?
But we can learn.
I'm sure you could, Mr. Maqetuka. But it would take you years to study the relevant subjects, not to mention the years of experience that are required to maintain a farm of this caliber.
We've got the time.
You've got the time. But do you have the money?
Not yet.
So let's say this court grants you and your people permission to move back to Tomori. Your plan is what? To pack your bags and move back? Somehow learning commercial farming skills on your way there?
I object, milady. My learned friend is blatantly attempting to confuse the witness.
Miss Mananga, please get to your point.
Apologies, my lady. The point here is that the Maduna community lack the sufficient know-how to run the respondent's farm. Mr. Maqetuka, you are an intelligent man, but surely you must know that the decision to move the entire community back to a commercial farm is nothing short of, well, ridiculous.
Unfortunately, in South Africa, it often happened, particularly with arable land, that people who had lived there for generations were forcibly removed from such lands. And then subsequently, the new owners developed either commercial farms or some other activity on the land that has got a commercial value. When the previous owners come forward and claim what was originally theirs, the question that the law must answer is who is more entitled to that piece of land.
if that is land which has been used productively and the community to which it is restored are not able to farm it and have the same production levels, that impacts on the economy, and therefore it's not in the public interest. It also impacts on that community because one doesn't want to set people up for failure.
There's been a number of cases where people have been given rights in land, but the actual practical implementation and the practical exercise of those rights hasn't really worked out. There's been various land reform projects that have failed, and I think it's a sensitive issue because it relates to the extent of support for people once they get land rights back, the extent to which the state supports them.
More generally, what's happening in land ownership in South Africa is that fewer people are owning more and more of the land. So since 1994, the number of commercial farming units has actually reduced quite dramatically from about 60,000 to under 40,000. What this means is that while commercial farming is growing as a part of our economy, it's actually producing fewer livelihoods and supporting fewer people's existence in the rural areas. And this is part of the motivation, of course, to have a land reform program that could enable more people to derive a livelihood from land and from productive land use.
Mr. Lobsha is also deeply invested in the land. But will this help his case?
I'm not the one responsible for their problems.
Having cultivated the land for the past 30 years, Mr. Lobsha saw the land as very much a part of his life and livelihood for him and his family.
Mr. Lobsha, how long have you been the owner of Tumori Farm?
20 years now.
How many people from the Maduna community do you currently employ?
32.
And of those 32, how many of them have the skills required to run a commercial farm?
I object, milady, on the grounds that that question requires specialist knowledge. Mr. Lobsha is not an expert witness with regard to the farming skills of his employees.
Overruled. Continue, Miss Mananga.
Thank you, my lady. Perhaps it would please my learned friend here to know that Mr. Lobsha here has been successfully farming for over 30 years and is thought of as an authority on the subject in various agricultural circles. So I repeat, does anyone from the Maduna community have the skills required to run and maintain your farm?
No, absolutely not.
No further questions, my lady.
Mr. Lobsha, you are aware that the Maduna community's cherished gravesite resides on your land, are you not?
Of course. I allow them to visit the site.
Allow. Interesting choice of words. I understand there are allocated time slots for when the community wishes to visit the site?
Correct.
What happens when someone wants to visit the site at a non-allocated time?
They are turned away.
Turned away? That's a nice way of saying you chase them away in trucks, don't you think?
I object, my lady, on grounds that that allegation is pure hearsay.
Do you intend presenting eyewitness testimony to this, Mr. Naidu?
Yes, milady. I will call 3 witnesses who will testify that they were chased off the property by trucks belonging to the respondent.
Please continue, Mr. Naidu.
Thank you, milady. Mr. Lobsha, is it true that not only have you and your family chased the Maduna people away with trucks, but that you have set your dogs on them on more than one occasion?
They trespassed on my land.
And that was your solution? To chase them off like animals?
I'm not the one responsible for their problems. I shouldn't have to pay for something that I didn't do.
One can never ignore the fact that there's a very strong bond between land and the people who have occupied that land. And that's where ancestral grave sites, burial practices and so on would come into play. People don't want to lose the land on which their ancestors are buried, and that's one of the things that is taken into account.
Should the Maduna people win the land claim, what would happen to the life Mr. Lobsha has built on his farm?
In the case of the property owner, the state cannot just simply take that land away. The person that is the owner of that land, if it's subject to a successful land claim, would be entitled to compensation for that if that land is expropriated.
The Act speaks a lot about restitution, which is to restore back to the previous owners. But restitution in itself does not necessarily mean taking the land and giving it to the previous owners. Restitution takes a number of forms. In some instances, restitution has been by way of compensation, financial compensation. So whoever is currently occupying the land is permitted to stay on the land, but some amount of money is paid to those who were forcibly removed. In certain instances, communities have been relocated to given other land, not the one that they originally owned, and that is deemed to be a fair exchange, and then the claim falls away.
Or the claimants can get some form of developmental support in the places where they live now, rather than uprooting themselves and returning to the land they lost. And this has taken the form of, for instance, investment in schools, in income-generating projects, in clinics, in infrastructure like road infrastructure. So in some cases, the priority is for development in the situation where they are now, rather than the return to the land that they lost.
There's no denying that the forced removal of the Maduna community was an undeserved injustice. However, in light of the circumstances, the solution is for them not to move back to the old Somori. By removing Mr. Loebscher from the farm that he has built into a successful commercial operation, the court would run the risk of compromising productive land without knowing if it would bear fruit in the future. This could amount to a step backwards for all concerned and would solve nothing in the long run. In terms of compensation, a fund will be set up by the state in order to pay for the planning, execution and maintenance of certain facilities, namely a primary school, a high school, a fully equipped clinic and a tarred road. The pressing issue of water accessibility will be seen to immediately. Finally, concerning the grave site, I'm ruling that the Maduna people be granted unlimited access at all times.
The court also ordered that each family in the claimant community be granted monetary compensation, the specific amount of which would be determined at a future court date.
Across the country, the settlement of land claims has brought a sense of justice and of the past injustice being redressed to many people who were unfairly treated in the past. And it has done so through a process that has tried to be even-handed by negotiating with landowners rather than forcing them off the land. But I think that we have now reached the point with many land claims where we're going to have to confront the tension between the interests of landowners and claimants. The Constitution protects the rights of both those who own land, but it also protects the rights of those who are unfairly dispossessed. And when these rights come into conflict, the state will have to make a ruling and a judgment call around whose rights take precedence. And I think that that will have to mean in the future the question of expropriation being relooked at.
The original deadline for lodging a claim at the Land Claims Commission was set for 31st December 1998. If the Commission is unable to resolve a disputed land claim through mediation, it will refer the dispute to the Land Claims Court. Alternatively, parties may refer their claim directly to the Land Claims Court. The court has wide powers to order restitution, which may take a variety of forms, including restitution of the original land, compensation, or upgraded facilities and resources on alternative land. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.